Is Mr. Charles Evans Hughes a natural-born citizen within the meaning of the Constitution? A legal examination of the subject by Breckinridge Long of the St. Louis Bar. Whether Mr. Hughes is, or is not, a natural-born citizen within the meaning of the Constitution, so as to make him eligible, or ineligible, to assume the office of President, presents an interesting inquiry. He was born in this country, and is beyond question, native-born. But is there not a distinction between native-born and natural-born? At the time he was born, his father and mother were subjects of England. His father had not then been naturalized. The day after Mr. Hughes was born, his father had a right, as an English subject, to go to the British consul at New York, and to present his wife and infant, and to claim any assistance he might need from the consul as the representative of the English government. If war had broken out between this government and England, this government would have had a right to intern the father, the mother, and the son as subjects of an enemy power. The Constitution of the United States puts a particular qualification upon those who shall become President and Vice President. For all other offices, it requires that they be citizens of the United States, but for the Presidency and Vice Presidency, it requires that they be natural-born citizens. The word natural means of the nature of, naturally a part of, by the laws of nature, an integral part of a system. Following that line of thought, a natural-born citizen would be one who was, naturally at his birth, a member of the political society, naturally a part of the political system into which he was born, by the laws of nature, a citizen of the society into which he was born. It would mean, further, that no other government had any claim upon him, that his sole allegiance was to the government into which he had been born, and that that government was solely, at the time, responsible for his protection. Native-born does not mean quite the same thing. He might be born in a country under conditions similar to the conditions under which Mr. Hughes was born, and subsequently become a citizen of that country. In that case, after he became a citizen, he would be a native-born citizen, but he would not have been a natural-born citizen from the instant of his birth. This government would not be solely responsible for his protection. Mr. Hughes was born before the adoption of the 14th Amendment to the Constitution, so the status of his citizenship must be considered as under the laws existing prior to the time of the adoption of that amendment. The only reference in the Constitution to the subject, except that section specifying the qualifications for president, is that Congress shall have the power to make uniform laws to provide for naturalization. Congress, under that authority, enacted the following law: the children of persons who have been duly naturalized under any law of the United States, being under the age of 21 years at the time of the naturalization of their parents, shall, if dwelling in the United States, be considered as citizens thereof. That statute says that children born of persons who have been duly naturalized become citizens, but become so by virtue of the act of the parent. That is, they become naturalized citizens. They are citizens by operation of law. They were not born so, but, because of the act of their father, are invested with all the rights of citizens. If they are born in this country, and their father subsequently becomes naturalized, they then, upon the naturalization of the father, become citizens. After becoming citizens, they are native-born citizens, but they are not natural-born citizens. That is, they are not born, in the nature of things, and by the laws of nature, a citizen of this republic. If the father becomes naturalized before the birth of the child, and is, at the time of the birth of the child, a citizen of the United States, then the child is a natural-born citizen. But, in the case of Mr. Hughes, the father was not naturalized at the time the son was born, and was at that time a subject of England. how could the son be a natural-born citizen of the United States? If you had been born in England, of American parents, would it be necessary for you to be naturalized if you came to this country to reside? No. If he, born in this country, of English parents, had returned to England to reside, would it have been necessary for him to be naturalized there? No. If it was not necessary for him to be naturalized in England, would he be a natural-born citizen of the United States? The statute above referred to announced the law of this country to be that the children of persons who should be naturalized became citizens by virtue of the act of their father, and obversely that they were not to be considered as citizens until their father was naturalized. The naturalization of the father operates to confer the municipal right of citizenship upon the minor child. Secretary Blyne, February 1st, 1890. It is admitted that the legal status of the child, under the circumstances we have to deal with, is not explicitly defined by the statutes. But any question which the reading of the statute does not clear up is elucidated and illuminated by the courts and official documents written by men in authority invested with the administration of the law. In this connection, it will be pertinent to make a few allusions to the recommendations made to Congress, urging them to clarify the situation. President Arthur, in his fourth annual message, in 1884, said, "Our existing naturalization laws also need revision. Section 2172, recognizing the citizenship of the children of naturalized parents, is ambiguous in its terms. A uniform rule of naturalization, such as the Constitution contemplates, should, among other things, clearly define the status of persons born within the United States, subject to a foreign power, and of minor children of fathers who have declared their intention to become citizens." President Cleveland, in his first annual message, in 1885, said, "The laws of certain states and territories admit a domiciled alien to the local franchise, conferring upon him the rights of citizenship to a degree which places him in the anomalous condition of being a citizen of a state, and yet not of the United States, within the purview of federal and international law." The United States Supreme Court has said, "The existing provisions leave much to be desired, and the attention of Congress has been called to the condition of the laws with reference to the election of nationality, and to the desirability of a clear definition of the status of minor children whose fathers had declared their intention to become citizens." Again, the United States Supreme Court says in the same case, "Clearly minors acquire an inchoate status by the declaration of intention on the part of their parents. If they attain their majority before the parent completes his naturalization, then they have an election to repudiate the status which they find impressed upon them, and determine that they will accept allegiance to some foreign potentate or power, rather than hold fast to some citizenship which the act of the parent has initiated for them."